This is Trademark News. I'm Hayley Tarr. Welcome to episode 3. In this episode of Trademark News, we focus on exam reports that have issued this week. Not surprisingly, an exam report has issued in relation to a certification trademark application for MANUKA Honey, filed in the name of MANUKA Charitable Trust. There are currently 11 other trademarks comprising MANUKA and honey for honey in Class 30 in the name of various Australian and New Zealand entities. If you've had your head in the sand and are unaware of the ongoing saga relating to MANUKA Honey, you might want to read a recent article in ABC News on the subject, written by Clint Jasper. Clint says the New Zealand MANUKA Honey Appellation Society argues that MANUKA is a Maori word and has attempted to trademark it in their home country, as well as in the USA, UK, EU, and China. The Australian MANUKA Honey Association, which has appointed 2 Maori board members, has demonstrated the word has been used in Australia to describe the plant and the honey produced from its pollen since the 1930s. Previously, hard-fought battles in both the US and the UK have held that MANUKA honey is produced in both Australia and New Zealand, such that New Zealand does not have exclusive rights to use of MANUKA honey as a geographic indicator. It will be very interesting to see whether the applicant can achieve acceptance of this application at all, but if it does, there will likely be a lot of activity in relation to the oppositions. It seems the MANUKA Charitable Trust is walking into a bit of a hornet's nest. Aristocrat Technologies, a prolific filer having over 1,500 Australian trademarks so far, has filed a new application and received an exam report this week for Mighty Genie for its electronic gaming or gambling machines. Well, from gambling to smoking, there have been some interesting developments in relation to tobacco products this week. British American Tobacco Australia Limited have received an exam report in relation to their trademark application for RVA, Responsible Vaping Australia, for education, scientific research and lobbying services in classes 41, 42 and 45. Obviously, that research is being funded by British American Tobacco Australia Limited and will be released into the market to inform consumers about how to vape responsibly. On British American Tobacco's website, it states clearly that British American Tobacco is one of the world's leading vapor companies under its flagship Views brand. The Views brand is registered to an entity called Nico Ventures Holdings Limited in Australia. And you can read between the lines as to how that new research might impact upon the profitability of the company selling the Views brand. Another tobacco company, Philip Morris Brands, SAL, have also received an exam report this week in relation to their trademark application for Marlborough Crafted Selection for goods such as liquid nicotine solutions for use in electronic cigarettes in Class 34. Now, this is very interesting because the Tobacco Plain Packaging Act of 2011 only requires plain packaging on tobacco products, but many of these vapes include synthetic nicotine and other unknown substances which do not come from a tobacco plant and are therefore not tobacco products, which provides a loophole for these companies. On unrelated matters, there have been 2 applications which have received rejections this week for ONDC stylized. Now, these applications were filed by the Commonwealth of Australia as represented by the Department of Finance. I've addressed this issue in a previous LegalWise article titled "The Trademarks Register as a Crystal Ball," and the reason why I find this very interesting is it creates a phenomenon where one branch of the executive is blocking another branch of the executive. Now that an objection's been raised, if that objection is withdrawn and the application's accepted either before or after a hearing, could it be argued that there has been a conflict of interest because there's no separation of powers here between these 2 different branches where one is accepting an application by the other? Should applications, for example, that receive objections from IP Australia have to go to judicial analysis before the Federal Circuit Court in order to be accepted validly without any implications of conflict of interest. Now, again, Brisbane Markets Limited have received an objection for their application for Saturday Fresh Markets. This is of personal interest to me rather than any interest of any other note, but just of interest to me because I'm quite proud of the fact that I was the attorney who prepared the voluminous evidence to achieve registration of Brisbane Markets for this client for markets held in Brisbane. Now, related to food, again, Hello Foods Limited have received an objection this week for their trademark application for Pasta Nostra. Now, Nostra means our in Italian, so translated into English, this mark means our pasta. It thus brings to mind the recent High Court decision regarding Oro and Cinque Stelle, where the High Court did ultimately decide that those words were not shown to convey a meaning or idea sufficiently tangible to persons in Australia concerned with coffee products as to be words having direct reference to the character or quality of the goods. Sorry, that was a mouthful, but that was an exact quote from the decision. So I guess those words were found to be inherently adducted to distinguish. So it'll be interesting to see how it plays out with Pasta Nostra. If you're a fan of the Apple TV series We Crashed, you might think that WeWork was no more, but you should think again. WeWork Companies, LLC, have received an objection this week for their trademark application for Common Desk. So it seems to be that they're still in business and are potentially trying to whitewash a little with a fresh brand, Common Desk, and continue trading under a bit of a different persona. Now, if you like me and you like TED Talks, and I highly recommend anything by Simon Sinek if you're interested, you might be interested to hear that TED Conferences has received 3 adverse reports this week in relation to applications for how to connect in a divided world, how to nurture your imagination, and how to boost your brain and memory. All of these are in class 41, so educational type services. It's understandable why they received these objections. They're all quite descriptive. It's a bit cheeky of me, but perhaps they should have watched some of their TED Talks on how to nurture your imagination before they filed these applications. Forgive me, TED Talks, I still love you. And lastly, Morrison & Forster have filed 4 applications and received exam reports for each of those this week. It's for a series of trademark applications for their MOFO brand. Now, many Australian lawyers and patent trademark attorneys might not have heard of MOFO, but I came across them in my time in New York. They're a very progressive, very cool law firm, and they're clearly planning to carve out a place for themselves in the Australian legal market. It does make perfect sense on the back of other big players such as Dentons successfully entering the Australian market. Many international law firms are likely to follow suit. So more competition for Australian lawyers from all angles. I did have the pleasure of hearing Michael Dempsey speak last week in an event for entrepreneurs and investors, and he mentioned that he's working on a startup to disrupt the legal industry. If it goes as well as Easy Debit, which many of you would know was sold for over $300 billion about 13 years ago, then we all better watch our backs. So lots of activity in the legal space this week. Well, that's all for Trademark News for now. I'm Hayley Tarr, and see you soon for our next episode.